Good morning, everyone. It is 7:11 of 2024, so go get yourself a Slurpee if, for the unofficial holiday. But I did want to take a look at the Daniel Muir case. It is kind of blowing up. There is an emergency habeas hearing today about some of maybe the possible legal shenanigans that are going on in this case. But I did want to give you a little background since I am not you know, as knowledgeable about this as I am about the goings on in maybe the Delphi case. So we can kind of take a look at the local reporting. This is from July the 10th. It was updated. Ex Colts player Daniel Muir, wife granted emergency hearing to determine if they are being illegally jailed in a child a CA case. So this case does involve, allegations of CA, laying hands on children. So, if this is something that will bother you, please, this might not be the video you want to watch. I never want you to put your mental health in jeopardy just to watch one of my videos. So, if this is not going to be something that you can watch, I completely and totally support you not getting involved in this case, not watching this. I have plenty of other videos, nightly newsy news. So there will be absolutely no upsetness from me if this is maybe not a case that you can handle right now. This is from Cass County, Indiana. Lawyers representing former NFL player Daniel Muir and his wife in the case of their son's disappearance and alleged abuse will now have a chance to argue in court that the couple is being held in jail without bond. On Wednesday, Cass County courts granted an emergency hearing for the Muirs, which is set to be held at 3 p.m. today. Muir, a defensive tackle who played for the Colts from 2008 to 2011, is currently being held in Cass County Jail along with his wife Kristen after he was arrested last week on charges of obstruction of justice and DV. The case background. The arrest stems from a weeks-long investigation by the Indiana State Police into allegations that Muir had, laid hands on his 14-year-old son at a religious compound they lived on in Logansport. So this is, we have covered this in Newsy News. This is the case where, people could not find this gentleman's son, and he was basically at this compound. The parents weren't cooperating. So it is definitely a fairly big case in Indiana, and it has been something that we have covered on Nightly Newsy News. Muir's son was a subject of a silver alert after he fell off of Indiana State Police's radar and was eventually found safe during a raid on July 3rd at the Straightway Indiana Goshen property on U.S. Highway 24. The mother of Kristen Muir, Daniel's wife, told authorities on June 16th that her 14-year-old grandson was suffering from a black eye and that his father had reportedly laid hands on him. When authorities pulled over Kristen's car minutes later, the son was nowhere to be found. For more on the grandmother's allegations, we can go to that. But right now, I just kind of want to focus on the case. Um, you know, I'm I I don't want to get into he said, she said without, getting into the case and what the state believes it can prove. Indiana State Police began working with Child Services to locate the child and ensure that he was safe, but Kristen and Daniel were reportedly uncooperative. The couple backed out of a meeting with police scheduled for June 28th and refused to show their son was with them and okay. Eventually, police gathered enough evidence, including a reported confession where Daniel said he had, quote, whooped his son's A like a grown man, to descend on the Muir's property with air support, armored cars, and SWAT crews. After the 14-year-old was safely recovered, both parents were arrested for obstruction of justice, and Daniel was given an additional charge of battery. Now, lawyers representing both Daniel and Kristen are arguing that Cass County Sheriff Ed Schroeder is illegally and unconstitutionally holding the couple in jail. The habeas corpus petition. According to Nathan Vining, filing a petition for a writ of habeas corpus Monday in Cass County Superior Court Number 2, arguing his client Daniel is being detained against his rights. While filing motions, the Muirs, Kristen, is never specifically mentioned. In the petition, Vining argues against the judge's decision to deny the Muirs bonds that cited the couple as a flight risk. During a court appearance that took place the day of their arrest, a judge reportedly said that a bail hearing could be set for a later date. Vining goes on to say that bail is a fundamental right in both state and federal constitutions, and argues that Daniel is entitled to bail because he is not accused of a serious offense such as murder or treason. When bail is denied outright for a defendant charged with a level 6 felony, it imposes a punitive measure without a trial or conviction, subjecting the defendant to conditions that are excessively harsh in compared to the alleged offense, Vining wrote. In his request for relief, Vining asked that the court immediately grant Daniel a petition for a writ of habeas corpus and order his release from custody. The Muirs' next court date is now scheduled for 3 p.m. on July 11th, where the judge will review the writ of habeas corpus filing. Signs at the secluded Logansport property make no mention of the Servant Leaders Foundation, which records show is the registered owner of the property. Multiple signs say "Welcome to Straightway Indiana Goshen," along with a crest. Other signs warn against trespassing and state that the location is private property. An internet search leads Stairway Ministry, a Tennessee-based religious group that describes itself as, quote, a nation of Hebrew Israelites who are commandment keepers, obedient to Yah or God and our Savior Jesus Christ, end quote. The group's official YouTube page features a video from 4 years ago and shows a man appearing to be Daniel preaching to a crowd. Some have described the group as a cult. Kristen Muir's mother said she feared her grandson was being brainwashed and couldn't bring himself to leave his parents. He is so conditioned or brainwashed to their way of living, the grandmother said earlier this month. Vining spoke with reporters after the parents went before a judge last Wednesday afternoon. The Muir family, they've been improperly targeted and are not guilty of any abuse or illegal activity. They are entitled to their day in court and due process, Vining said. Pastor Charles Dow, who leads Straightway Truth, posted several videos in the wake of the raid on YouTube. In one of the videos, Dow said not to trust news reports or police reports about the allegations involving the Muir family. Quote, "You better believe that Straight Away is not going to be taking any of this lying down," Dowell said. "We are coming. You better believe we're coming." Sport Illustrated previously detailed Straightaway Truth and Pastor Dowell in an extensive report in which many people accuse the religious group of being a cult, among other troubling allegations. So I will definitely be bookmarking this extensive report. But knowing that, you know, every report, every sort of thing that you get from the mainstream media does have an angle. I, I have made no judgment call, yay, nay, about how this is going or this, religious organization. But I will be going through that article. But this is the probable cause affidavit. And as we know from the Richard Allen case, we can kind of see where there may be holes in things if we go through the probable cause affidavit. Obviously, some of these things have been redacted because there is a minor involved. So, and we are probably not going to hear some really nice things in this because it does involve, the allegations of laying hands on a child. So I will try to make it as YouTube friendly, but give you guys the gist of this if I can't read something outright because, So, probable cause affidavit, State of Indiana, County of Cass against Daniel T. Muir. I, Detective Joshua Mahler, PE. I'm not going to give you a state number. I mean, y'all can see it on the screen if you want. Of the state, Indiana State Police Department, being first duly sworn upon oath, says that on or about June 13th, 2024, in the county of Cass in the state of Indiana, the following offenses did occur. So in Logansport, uh, on or about June 18th, 2024, state police field investigations was requested to investigate allegations of DV involving a juvenile. The initial report was provided by Cass County Department of Child Services via preliminary report of alleged CA or neglect, report number 3089777. The report alleges physical abuse in which a 14-year-old was observed with an injury to his right eye. Two photographs were presented with the report to show blank with swelling and bruising around his right eye. Uh, the son is inside the residence photograph, inside a residence in the photograph, possibly holding a homemade ice pack. The photograph depicts no visible blood incisions or lacerations. The DCS report describes the child's injury as a direct result of punishment dealt by his father, Daniel Muir. So they do have evidence, they do have photos, and it is alleged that this happened because of his father. On June 20th, 2024, the affiant conducted a recorded phone call with Cheryl J. Wright. Miss Wright is the mother of Christian Muir, who is the mother to the child. Miss Wright reports having seen the child on June 13th, during which time he stayed with her until June 16th. When the child was dropped off, she describes seeing the black eye. She questioned the child regarding how the injury occurred, and he advised that his father had punished him. Ms. Wright reports taking the photographs that were included with the DCS report, also uploaded as evidence for this case. Ms. Wright reports Kristen Muir's brother, Cameron Wright, conducted an audio recorded call with Daniel Muir. The recordings seem to start mid conversation. Mr. Muir is in the process of telling Mr. Wright the reason why his son was in trouble. He reports that his son was showing his private area to other kids and touching the privates of others. Now, this all has not been, adjudicated in a court. And so these are all allegations. This is a recording taken without, Mr. Muir's consent. So we really don't know what the story is going on. Mr. Moore informed Mr. Wright because of this happening, uh, the child is unable to be quote unquote here. Mr. Muir reports he learned of this through fathers of the kids that were touched after they disclosed the incident to their parents. Muir described that the kids that, his son allegedly was purported to have touched as two 5-year-old boys and one 8-year-old boy. Mr. Wright asked, if the child, Mr. Muir's child, had ever been a victim of SA. Mr. Muir reported that his son had never been SA'd before or suffered from that type of abuse. Mr. Wright confronted Mr. Muir regarding the injury to his son's face, and Mr. Muir confessed that he, quote, this is a quote, YouTube, do not listen, this is not my stuff, whooped his A because he touched 3 little boys' penises and had them touch his penis. YouTube, don't come after me. I am reading a quote. Muir stated, I whooped his A like a grown A man, end quote. I mean, if these are actual statements that they have, but again, I do not remember if I believe Indiana is a single party consent state, but with this recording seeming to start halfway through a conversation, again, if this man, I stand no one who lays a hands on a child. So if the court can prove this, with actual evidence instead of, undercover Nancy Drew relatives going on here, then let's put them in prison, okay? I think you guys kind of all know the tenor and the fact that I give no, you know, leeway to people that hurt children. But it seems like there are a lot of things that are going kind of shady in this particular case. The phone call continues after these statements for approximately 15 minutes with no additional statements of evidentiary value. There is a noteworthy statement in which Mr. Murr states that if they lived in their homeland, religious homeland, that blank would have been put to unalivement uh, for his acts. Instead, they live in the United States, so they cannot do that. Now, there are not quotes around that, so I don't know how he exactly worded that, but that is a terrible statement to make from your own child. Yes, it does seem like if all of these things are true and the son did do this, then it does seem like there needs to be some intensive help for the young boy, because where is this behavior coming from? Where are these sort of, ideas and thoughts that you are allowed to put your hands on other younger children coming from? Um, I don't know that this would ever be something that would come out of my mouth, but on top of all that, it doesn't seem like there are quotes, and they seem to have had no problems putting quotes around his other statements that are very incriminating. So I do question why they don't have this specific statement in there. On June 27th, 2024, Indiana State Police arrived at the DeKalb County DCS office and met with Daniel and Kristen Muir, accompanied by their attorney, Nathan Vining. During our initial interview, Mr. Muir provided observations of several videos of his son. In the videos, his son was observed standing in an undisclosed location, possibly in a wooded area. The videos are consistent with an question answer scenario. However, the questions were never observed being asked. An example of what blank would say in a recording is that, quote, my father did not, hurt my eye. The recording would immediately end, and Mr. Murr would play the next video containing a similar statement. Mr. and Mr. Murr agreed to separate interviews. Ms. Murr then met with investigators without legal representation. During the audio video recorded interview, she described that, her son was talking trash and how he liked taking the trash out, and he likes trains because of his information. Not talking trash, taking the trash out, y'all. Because of his interest in trains, she walked over to the train tracks near the property. While near the tracks, the son reported having been punched by an unknown individual. When he returned home to report what happened to his parents, with blank's safety in mind, Mr. and Mrs. Murr then decided to move to Mrs. Murr's, mother's home, Cheryl Wright, who is located in Ohio. A few days after, Miss Murr reports that her mother was making decisions she did not agree with, and they decided to remove him from her care. Upon arrival, Miss Murr reports that her mother was resistant to her taking, her child away from the grandmother's residence. She was able to collect her son and reports that he was immediately taken a short distance away to a family member's house. Miss Murr then describes how, as they were driving back to Indiana, they decided to pull over so she could feed another child, breastfeed. During which police arrived and reported they were looking for the child and he was not in the vehicle. She reports after the traffic stop, they returned to their home in Logansport, Indiana. Miss Murr met with investigators with the legal, or Mr. Murr met with investigators with legal counsel present. During the audio video recorded interview, Mr. Murr described a consistent incident as Miss Murr did regarding how, his son received the injury and everything leading up to when they collected the son from the house of Miss Murr's mother. Their stories are inconsistent at this point, as Mr. Murr described how on the way home they were pulled over. According to Mr. Murr, the child was in the car when stopped. However, he states the police said they were looking for a 14-year-old female and not a male. Mr. Murr states he told them there wasn't a person in the car fitting that description. They were then allowed to leave and returned home with their child. Mr. Murr indicated it was days later that the child was transported to another location and gave cause being the DCS removal order. He wanted to protect his family. He reports that his child was transported to another location by family. However, he would not disclose the location. On the same day, Indiana State Police escorted DCS to the Murr residence to conduct a home inspection. While at the residence, they conducted interview with the verbal children. Below is an excerpt from the family case manager, Alexis Little's report. FCM Little spoke with the child individually, but in the presence and view of everyone. Uh, she inquired if this child felt safe at home. Spoke He spoke of feeling safe at home. FCM Little inquired if the child knew what safe means. The child stated that safe means when you are protected. FCML Little inquired if the child ever felt unsafe or scared at home. The child denied ever feeling unsafe or scared at home. FCM Little asked the child if all of his basic needs were met. Uh, the child spoke of all of his needs being met, including food, water, bed, and bedding. FCM Little asked the child what happens when he gets in trouble at home. The child states he gets in trouble, he's corrected. FCM Little inquired with, the child what corrected looks like. The child stated his parents talk to him and tell him to do better. Now, I have a couple of issues with this. If you truly believe that there is some aggressive parenting, some, CA going on, why are you interviewing this child in front of his parents, open in front of everyone? That is the quickest way to get an abuse victim to not talk because they are terrified. So if you really believe that this child is getting the stuffing, taken out of him, why aren't you interviewing him away where he feels safe, where he can disclose things not in front of his parents? I mean, this already seems like a setup where DCS did not think these things through, in my opinion, and you are free to disagree with me in the comments, but this seems like, asking a female victim of DV right in front of their, aggressor, how are things going? And, you know, most victims are not going to have the cojones right at that time to say, he's the problem. He keeps hurting me. Please take him away. I mean, 9 times out of 10, with, that person right next to you, you are going to lie if you are in the position of being a victim or being, broken down by this person. FCM Little asked if the child was ever corrected or disciplined in another way. The child stated he also gets spanked. Uh, FCM Little inquired with the child where on his body he gets spanked, and the child stated he is spanked on his behind, arms, and legs. FCM Little inquired with the child what he is spanked with, and the child stated he was spanked with a green piece of water hose. FCM Little asked the child if he could remember the last time he was spanked where it resulted in marks, bruising, or injury, and the child stated yes. The child stated last December his father, quote unquote, whooped him in his room. FCM Little inquired with the child why he was in trouble, and he stated because his mother had popped him in the mouth and the child had jerked and flopped around. Okay, well, I mean, that's When FCM Little asked what being quote unquote popped in the mouth looked like, the child took his hand and motioned with the palm of his hand to his mouth. The child stated being popped in the mouth did not result in any marks, bruising, or bleeding. The child stated after this, his father, quote unquote, whooped him with a green hose on his legs, arms, and behind. He stated he had bruising on his legs, arms, and behind as a result of the incident. FCM Little inquired if there were any other times when the child had been whooped or spanked and it resulted in marks. The child stated yes. The child recalled another incident that occurred last May. FCM Little inquired with the child as to what he was in trouble for, and the child stated he was in trouble for trying to poke holes in the wall of the home. The child stated his father spanked him on his arms and behind. The child stated he had bruises on his arms and behind as a result of the incident. The child stated his nose also started bleeding as a result of the incident. FCM Little asked the child why his nose bled, and the child stated that his father popped him. Again, if we have evidence that this is not a safe home, get him the heck out of there. I have no problem with this. You guys know that any sort of injustice that happens to kiddos frosts my flakes, burns my biscuits, and makes me very, very ticked off. But I also think that there are a lot of things that are going on with this family dynamic that need to be investigated further. And these are allegations. And if we are treating someone differently because of these allegations than we would anyone else, then that is not how our justice system works. The justice system needs to be fair for, the dumpster water people and saints. We can't have different rules because we find that this crime is personally more upsetting to us than other crimes. And I get the desire to want to do that because children are my soft spot. They are my kryptonite. And I get wanting to just lock away the door or, lock the door, throw away the keys when these kind of allegations are brought up. Uh, you know, but we need an actual investigation that has proof that shows that this is a thing. And the parents also need to be afforded their constitutional rights at the same time. You don't have to agree with what they do. You can think that they went too far. And from what I'm seeing just in this document, it does look like allegedly some lines were crossed, but they still get the same access to due process as everyone else, even if you think they are trash water human beings. And that is something that I struggle with maintaining that due process thing. But it's definitely something that we have to keep in mind. Uh, the child recalled a third incident where he and another child were told to clean their room. FCM Little noted that the child hesitated and began looking around the room at others who were behind FCM Little. FCM Little, the child appeared uncomfortable and started shifting away from eye contact. This is why if they truly believed that there was something of this caliber going on, if there was actual CA, they should have taken this child out from, the family living room with all the family looking at him and absolutely question him, or have a forensic psychiatrist, you know, question him. I mean, again, you're doing this in open view of his alleged abusers. What do you think he's going to say? And rubbing his hands together. FCM Little advised the child to take his time and it was okay if he didn't remember. The child then refocused on FCM Little and indicated he remembered. He stated he told his parents the room was clean. The child stated his parents came to check the room and it was still messy. Uh, the child stated his father popped him in the mouth, which did not result in any marks, bruising, or injury. The child stated he also got the rod. FCM Little inquired what that meant with the child. The child stated that meant he got spanked with a belt. The child stated he was spanked on his behind and it resulted in bruising. At this point, Kristen stopped the interview. Kristen expressed concerns that the statement the child was making would be misconstrued. Kristen stated none of the children in the home are abused or neglected. Kristen further stated that the child would continue answering all the questions FML Little asked, and uh, the child remembers everything. Kristen stated she was not comfortable with FCM continuing the questions regarding discipline. Uh, the child's brother interjected, stating the department was asking leading questions. FCM Little spoke with FCMS Neher briefly away from the family and child about the physical abuse disclosures the child made thus far. It was determined FCM Little would move on from this aspect of the interview. FCM Little rejoined the family and explained that FCM Little would continue to different topics. FCM Little then went back over to uh, the child who was sitting on the couch. FCM redirected the conversation and inquired with the child about body safety. The child was not aware of what the term meant, so FCM Little explained. The child agreed he was knowledgeable and had conversations about his body being private. The child denied ever having anyone try to look or touch any, private areas of his body and stated if something like this were to ever happen, he knows he can talk to his father. FCM Little observed the child to be dressed for the weather, to appear clean, well nourished, and meeting his milestones. FCM Little did not observe any visible marks or bruises on the child, and the child denied having any current marks or bruises. FCM Little then met with someone else individually, but in the presence and view of everyone. Blank spoke of feeling safe at home, so I'm guessing this is another child that they have. Uh, he stated that safe means no one's hurting you and you are safe with your parents. The child denied ever feeling unsafe or scared at home. The child spoke about all his needs being met, including food, water, a bed, and bedding. The FCM Little inquired to the child about body safety. The child was not aware of what the term meant, so FCM Little explained. The child agreed he was knowledgeable and had had conversations with his parents about his body being private. He denied anyone ever trying to look or touch at the private areas of his body and stated if something like that were to happen, he knows to talk to his mother and father. The child explains that when he gets in trouble, his parents either talk to him or he, quote unquote, gets the rod, which would mean a belt whooping, to put it in colloquial plain terms. CMC Little inquired what get the rod means. The child stated it means he gets a whooping on his behind. FCM Little inquired that if the child could tell FCM Little the last time this occurred. The child stated it happened on Saturday in the past, but he could not remember exactly when. The child stated his father whooped his behind, and it resulted in bruising and hurt afterwards. The child stated his mother and father both whoop him. FCM Little observed that the child was dressed for the weather, appeared clean, well nourished, and to be having his needs met, meeting his milestones. FCM Little did not observe any visible marks or bruises on the child, and the child denied having any current marks or bruises. FCM Little noted during the interview that the child kept looking around the room and he would look in the directions of others and quickly look down on the floor and lose focus on the conversation being had with FCM Little. Keep in mind, I don't know the age of this child, but my boys do this a lot, and they range from, 12 to 10 to 8. So my boys have a difficult time maintaining eye contact and staying on topic. Sometimes, it's a factor of ADHD and just being a wild feral boy. Again, these allegations aren't great, but some of these things could be attributed to them, again, this being a stressful situation. If they And I go back to, if DCSF was really, really worried that there was some severe CA going on, why interview these children in front of the entire family in an open area where these children would not feel safe disclosing any of these things beyond, maybe, I mean, if you go with the premise that DCFS thinks that there is, CA going on, they should realize that children are very likely to recant when in the presence of their parents doing the, CA, because, well, basic psychology. Again, I feel like this really, if this was a big issue and they were very concerned, then they wouldn't have set up the interviews like this. Now, I don't know if the interviews were set up like this because of legal finagling by the parents. Basically, we would like the children questioned in front of us. We don't trust DCFS. So I am not sure of the small, intricate details. I'm only going by the probable cause affidavit right now. So there were multiple people present in the home at the time of the interviews. It should be noted that other children are nonverbal children and therefore they were not interviewed. DCS photographed the children for identification purposes. Reference Cass Circuit Court Cause 09C01-2406- JC-00065. The court grants wardship over the child, to Indiana Department of Child Services as of 6/26/2024. So the court found exigent emergency exists on exigent circumstances. Having found that an emergency situation exists, the court now orders Daniel Muir and Christian Muir, the parents, guardians, or custodians of this child, to basically turn him over. A, to produce any and all children in his care or control, including but not limited to the children that were listed, at the request of law enforcement officers, family case manager, or a representative of the department, so that the condition of the child or children may be observed. B, if the child or children are not in the physical care of Daniel or Kristen Muir, to provide DCS with the address, contact information at which the children can be located, and the name of any other individual that the children are with. C, to allow a family case manager or representative of the department to access the child's home so that the condition of the home may be observed to ensure that the child is being cared for in an appropriate environment. D, to obtain any examinations or treatments of the children if deemed appropriate by the court. And E, to refrain from removing the child from the court's jurisdiction. At this time, it is apparent that Mr. and Mr. Muir have violated the aforesaid orders of the court. Examples of the violation include, but are not limited to: 1, not producing the child for inspection of his condition to either law enforcement or the Department of Child Services. 2, not providing contact information or whereabouts of, the child. 3, not providing current custodian of the child. And 4, not removing the child from the court's jurisdiction. Copies of this information were provided to Attorney Vining on June 27th while at the DCS office. On June 28th, Attorney Vining contacted the affiant via telephone on behalf of his client, Daniel Muir. Mr. Vining was attempting to set up a meeting with investigators at Indiana State Police Peru Post to transfer the child into law enforcement. The affiant confirmed that to transfer the child, or Mr. Muir, to the law enforcement. I'm guessing it's the child because it is blacked out, but sometimes these redactions make it a little harder to keep up with what's going on. But they were able, were willing to meet with the Murs at the Peru Post, and the meeting was scheduled for noon. At approximately 11:05 a.m., Mr. Vining called to inform the affiant that Mr. and Mrs. Murr were now refusing to meet and refusing to hand over their child. As of the writing of this narrative, Mr. Vining is attempting to have his clients meet with ISP to allow investigators to see a recent um, video of his son to ensure that he is okay. Due to the Due to the aforementioned probable cause, I'm requesting the investigation to be reviewed for considered charges or consideration of charges. We affirm that under penalties of perjury that the foregoing representations are true. Be it further known that the facts herein may be used by the prosecuting attorney in any manner he deems proper in the arrest and prosecution of the offender here named herein, and may be used against the affiant if the facts herein stated by the affiant are found to be untrue. Detective Joshua Mahler. So, this probable cause affidavit, I I think my biggest issue with this right now is that we are getting a lot of hearsay, and I understand the family, the grandma, the brother-in-law, wanting to get to the bottom of this. If I saw, a child I love with unexplained bruises, I think I'd wanna get to the bottom of it too. But right now we have a lot of hearsay. We have the DCS worker that, again, conducted an interview about possible CA with those, let's say, potential victims right in front of their abusers, if you wanna put it like that. And I find that to be grossly well, I just find that to be stupid. Anyone who has worked, or seen any sort of victims that have dealt with DV or CA can tell you that victims are more likely to recant if they are interviewed in front of their family, or they're more likely to stick to a script that has been worked out ahead of time. This this just seems like we have a lot of maybe smoke but no fire that I can tell, and we are holding these people in jail. And it is possible that the state has more information. It is possible that I don't know everything because I'm Mo and no one knows everything. I am willing to be humble and, think that there might be more going on that the state knows. But based on this probable cause affidavit, we have a lot of hearsay. We don't have a lot of evidence. And now they're holding both these parents without bail. There is just there is smoke here, but the differences in how we're treating this do raise some alarms for me with the state, and I will go publicly again if they find that if the state brings me evidence that they hurt this little child, their son, regardless of what he did, you know, then, lock him up after due process and throw away the key. That is not my issue here. My issue here is that it does not look like we have concrete evidence. And I understand that you're not always going to get that, but what we have right now is a lot of hearsay, and it doesn't seem like enough to hold someone without bond. And I think that's where the disconnect is. So thank you for hanging out with me on this longer video. And I know that these things are very difficult to talk about. The thought of someone, hurting a child is monstrous and very hard to think about. But I appreciate you for sticking through this with me, and hopefully my interview with Kara Winnicky, take on it. It's Kara. Look, I graduated from the Zoolander School of Reading Things Goodlier. Kara Winnicky, an attorney that's worked with helping set up the habeas meeting for later on today, will really shed more light on, maybe the more intricate details of things that I'm not seeing because I only have a layperson's experience with the law. So I hope you stay tuned for that. And thank you for joining me on this video, and have a wonderful day. Be kind to yourself, be kind to others, and I will see you in a little bit. Bye, guys.